Much for joining us. Thank you very much for joining us for our quarterly roundtable discussion of matters that are on the minds of mediators. And we are trying to cover things that will be of interest and importance to practicing mediators as well as litigators. So our topics today really include items that get mediators stuck and parties stuck when you're in mediation. And we've all been there when you think you're marching to a resolution and then all of a sudden something happens and you don't know what to do. So some of what we'll talk about this morning also will be what can you do in advance to prevent those things from happening. And one of the items that I know we talk about it at times in the employment law mediation world, and I'm sure it pops up in other areas, or when do you introduce non-monetary items? So a lot of times we focus on the dollars and cents and we go back and forth on that, but non-monetary items can be equally as important. So Trish, why don't you talk a little bit about what you do and how you handle non-monetary items and perhaps some of the items that have become stumbling blocks if you don't introduce them at the right time.
Sure. So Ann and I talked last week about this topic a little bit, and so I put together some thoughts as to what I run into primarily in the world that I mediate in, which is employment law cases. So, but I don't want this discussion to be centered just on employment law cases, because certainly non-monetary terms can cause parties to be stuck in a multitude of type of cases. But in the world of employment law, just as an example, the question is, when during the negotiations do you bring up non-monetary terms? Should you bring it up in the beginning? Should you bring it up even pre-mediation? Should you bring it up in the middle after much discussion about money, or towards the end of the mediation? And some sophisticated plaintiffs' attorneys, I find, will tell me early on, or excuse me, yes, sophisticated plaintiffs' attorneys will tell me early on that such terms are expected and acceptable, but some don't. And examples of what I'm talking about are confidentiality. Should it be mutual? If it's mutual, who of the defense, if it's a company, will be bound? Non-disparagement clauses. Should they be mutual? Should there be liquidated damages associated with them? A no reapply provision. Oftentimes in employment law cases, there's a request by the defense that the plaintiff not reapply to work with the company ever again, because if they're turned down, they might claim they're being retaliated against. And sometimes an apology is asked for. And then another one that's really tricky, I think, are wage and versus 1099 tax allocations. How much of the monetary sum that the parties are getting close to agreeing on will be allocated to wages subject to normal withholdings, or how much will be subject to a 1099, and the plaintiff can deal with their accountant as to just how to handle that. So I find that sometimes if you wait too long in a mediation, you can get so close on the monetary terms, and then all of a sudden the defense says, well, I require a release. And the plaintiff's attorney says, well, I require a mutual release. And then all of a sudden, everything starts to unravel. So then what do you do? Or if someone says, I require liquidated damages associated with my confidentiality clause if someone breaches it, how much? What's too much under the law? So those were just some of the things that I thought of. And one other one that Ann and I discussed that I thought about a little bit is this constant threat, if you will, that we hear from the defense in mediations that they're going to file and achieve summary judgment. And that's not necessarily the case in certain districts, particularly those of you who practice in federal court in the Middle District, where you often don't get a ruling on your motion for summary judgment until the day of trial, if then, it seems. So those were just some of the thoughts I had where I see people get stuck, and I'm not sure I have magical answers in my world. I'm prone to being a bit intuitive as to when I feel like it's appropriate to start talking about those terms. It's rarely in the beginning, it's usually somewhere in the middle. But I think if you wait too late, it can blow everything up. So I will
Thank
stop
you.
the talking.
No,
and let
that's great, Trish. So those are excellent thoughts. And Jackie, I see you've unmuted yourself, so I'm going to call on you. Do you want to weigh in on this
That was
issue?
not a raising of the hand. It was just, I just sometimes forget that I'm muted. Um, so I feel like the earlier the better on the terms. And I think in employment cases, you just have a lot more terms that, maybe it is best to, wait a little while. Um, Yeah, I think sometimes I'll have defendants make an offer and they'll say, and we're going to require confidentiality and a general release. Um, it's the main thing is just don't wait until the end. If the defendants say, oh, yeah, we're going to want confidentiality, and normally that's required in the cases that I mediate. And what kills me is if you wait to the end and plaintiff's attorney goes, oh, that's going to cost you, and that they knew it was coming, and then you have to deal with that. And you know that they're going to be okay with it because they knew it was coming the whole time. But if you wait too late, then you do get that kind of behavior. And so I think you really do need to deal with it early on. The other problem is, it can be so emotional to finally say yes, to an agreement. And so if you then throw that in at the end, particularly the parties, they're not familiar what the general terms are going to be. It just might give that opportunity to go, I'm changing my mind. And so I do think it's better to go on and work early on with those terms.
So, and it may be different in different areas of practice too. I hear what you're saying. Frank, I see you unmuted yourself, so I'm going to take that as a signal to call on somebody. So,
Well, thank
um,
you. There's one of my conundrums in this area is a balance between two items. Issues falling off the table and letting sleeping dogs lie. Which is it? So somebody comes out with a non-monetary term early on that the other side says, no, you're nuts. You would never get that in court. It's not, it's not illegal for me to give it to you, but there's no legal way that you would ever get there in the world that we live in. So the answer is no, we're not going to simply give that to you as a gift. And the other side, says, well, okay, but we still want it. And then you proceed to negotiate in monetary terms. And by the way, this is a case that I did one time. And so, I don't know, 5-6 hours later, we have monetary terms. And then I think it was the plaintiff says, but I still want the term that I asked for at 9:30 this morning. And the defendant blows up and says, what part of no don't you understand? You are not going to get it in court. We're not going to give it to you now. And by the way, in that particular situation, it was an indemnity clause. The defendant was going to indemnify the plaintiff if something ever went wrong in this transaction. And the defendant goes, we have no duty ever to indemnify you for any reason. If the transaction goes bad, it goes bad. I'm sorry, but we're not going to indemnify you. And so that's what that issue was about. So I had let it fall off the table, and I had assumed it was a sleeping dog that was just laying there, and I ought to just let it go and let it sleep. And then it blew up. So, and so when do you tell if that's an issue that's really gone away, or do you poke at it and say, are you really gone away, or do we still need to talk about you? So that's a balance that I've had issues with, shall we say, in my career. Usually I err on the side of being clear and explicit. That's what I would suggest. But I admit that there are times that the thing went away, and nobody explicitly said it went away, but we just stopped talking about it, and I let that sleeping dog lie, and it seemed to work. So I sort of like Trish, I don't have any magic answers for you, but I do raise the question. But I will say that my preference now with experience is to not simply say, well, that sleeping dog is lying, let's just let it. And instead be more explicit to say, okay, this was something you talked about, 2 offers ago or 3 offers ago. You're not including it now. Is it something that you still need, or can we just sort of cross it off and say that we can get it settled by handling these other terms? So I try to be a little more upfront about it.
So
And
have you had when you have that sleeping dog that's over there, and it needs to be brought back up, but one of the parties, you ask them about it, and they say, don't mention that, or don't talk about it. I don't want you to talk about it now. I want you just to focus on the money. How do you, I mean, I'm sure you've had that happen. How do you handle that?
Well, first thing I ask is a little bit about why. What is your concern about me addressing that with the other side, particularly considering it normally, in my concept, normally it's already been discussed and rejected. Why not go ahead and bring it back up if this is something that you really want? So, but also by telling me to not talk about it, are you saying that this is something you really want? And so I'll try to figure out what their arc of strategy is. And somebody just said something in the note that I didn't read. I don't know if they were talking to me or not. Sorry.
Well, Tara, let me ask you, because I know you bring kind of that family law perspective to the table, as in addition to your role at the DRC. Is there a difference, do you think, in family law cases versus our kind of traditional employment or other case?
I'm keep in mind that I've never actually conducted a Superior Court mediation, and I've only taken one of my clients through Superior Court mediation. But from my perspective at the DRC, I would say that there's a huge difference. In family law, it's technically the marital property that's been ordered into mediation, but it's much easier, or at least it was for me, on either side, whether I was representing a party or mediating a case, to kind of negotiate everything in one big lump sum. And so trying to wait till the end to talk about certain things was always a disaster from my perspective, right? From my personal experience, and laying things out in a very descriptive manner and kind of addressing all issues at the same time, even though it could be overwhelming. I found that it was much easier because with family law, at least with my clients, they were extremely emotional. And as soon as you throw in one last $500 term at the very end, it would blow up the entire thing.
And I hear somebody's microphone. If you're not speaking, if you would mute, that would be great, just to help. But yeah, Tara, so that was kind of what I would think in family. I see you have your hand up, so please jump in. And you're muted, Deb.
Sorry, I was going to ask that same question, Anne, because I know how I handle the non-monetary issues, even when we're just dealing with equitable distribution, because there are pot holders and pots and pans that come up. But I was curious as to how other practitioners may handle that before I pass on my opinion about how I handle that, because I do think it is different in the family law context.
And Rick, I know you do folks who generally are pro se, or you have a lot of experience in that area. Would you address how you handle introducing non-monetary items?
Well, a couple different ways. First of all, when I'm doing a family law case and I'm working with spouses who are not represented, which is often, I actually have a sheet of topics that I give them to start with. Things you might want to talk about, things that other people generally talk about, issues that generally come up. So I'm not saying, hey, you have to talk about these things, but it's just sort of like a prompt for that. So with those folks, I'm usually starting off, they're having a look at everything. So they're kind of on the same page about items that might come up, and this won't necessarily be monetary. So that's a start. It's also going to depend, and I know our practice, and certainly in Superior Court mediations or mediations where attorneys are present, we're doing our general session and breaking up into caucus. And in a caucus situation, I'm happy to, what else do you want to talk about? What's possible to come up now? And I'll go through those kind of things. And then we might have a discussion about when to bring them up. I generally believe in all mediations, it's better to bring them up early than to do a lot of hard work and then have this one little term, blow everything up in the end. It's happened to me a couple times in family cases. So that's kind of the way I do. It would be different if we were all together and we might talk about things together. The other side of it is when I'm doing a Superior Court case, when I've been appointed and I have a pro se party or parties, I like to spend some time. I think I've said this before in one of these sessions before. I try to talk as much as possible with the non-represented party before we actually get into the mediation about the process, about things that might come up, about what's your negotiation stance. Have you thought about what you would like to have here so you're not deciding on the fly in the mediation? So a lot of times things like that can come up, and then I've got it in mind, and maybe during the mediation we'll discuss when would be an appropriate time to bring that thing up. Or one of my favorite questions is kind of like Frank's question, why? How important is that to you? Is that a deal killer? I mean, because if it is, we really need to talk about that, and we need to be sure we get it out there and negotiate. If it's not particularly essential, then maybe we can put it aside and bring it up later and see what they say.
So Rick, I love your idea of topics. I had not ever done that before, and I'm going to put you on the spot, and you don't have to answer now. But would you be willing to share that list of topics?
Sure.
Okay.
I'll also share that I didn't come up with that on my own, and I'm in debt to several other mediators and trainers, and in particular Bill Eddy and his approach to high conflict individuals, and how to kind of cover everything early because things will pop up. And I think we've all been in mediations. It's already been mentioned, where you've negotiated something for several hours, and then at the end somebody goes, "Oh yes, and by the way, I need X, Y, and Z." And so if you can try to get that out early, I think it's much better. So
when do you give them the list of topics?
I will send it with them. If we're doing a family mediation, we're generally doing a contract. When I send my contract, I'll send, here's a list of topics that you might want to discuss. Sometimes, if possible, with non-represented parties in family mediation, I like to have at least a half an hour meeting with each spouse before we actually get into the mediation, for various reasons. And so sometimes I'll bring it up at that point. I'll send out I need an information sheet. I've got, financial information sheet that I send out to folks, and I'll send out that list with them also.
Can I jump in real quick?
Sure, please, Tara.
So I just want everyone else to know, because Rick's brilliant. So he knows that when he talks to the family parties individually, that he has to have consent from both parties, because the rules don't allow for ex parte communication if it's court ordered. And I know Rick does that. So I just wanted everybody else to know that that's one thing you need to look out for. But the commission also created a while ago a guide for an equitable distribution disclosure sheet that we have under the family resources in the mediator toolbox. Because we were hearing from a lot of mediators that pro se individuals would come to an ED mediation and not realize they needed to bring statements, right? Or disclosures for retirement accounts, et cetera. So it was very frustrating because you couldn't really do very much without all of this information. So we have something similar to that. It sounds like Rick's goes into much more detail, which is great. I love the list of topics idea, but I just wanted to make everyone aware that we had that out there. And then on the other flip side, when you're dealing with confidentiality, the commission recently has posted an agreement that pro se or represented parties can enter into. And we spent a lot of time working on this, trying to find the sweet spot where we're not giving legal advice, but we're providing individuals who may not be able to craft their own confidentiality agreements the opportunity to enter into those agreements. And the confidentiality agreement talks about not recording, and then also limitations on testimony by the mediator. So it kind of goes through a few different topics, but that is located on our more information link, and then under the information for parties without attorneys.
And
Oh,
if I
thank
may
you,
just add, thank you, Terry. You're very
Sure.
tactful the way you put that. I rarely deal with family mediations with folks who are in court. These will be prior to. So that's not generally an issue that I have to deal with. But you're absolutely right. Those are the rules. And if I'm getting something that's been ordered, definitely that's the approach. Yeah.
And I do want to commend Tara and the DRC on their website. It is excellent. If you have a question, take a look at it, because a lot of times the answers are there. I frequently will ask somebody else and then they'll tell me, oh, it's on the DRC website. So I just want to commend Tara and the staff for that that excellent website. Trish, did you have your mute button off for a reason?
No.
Okay. All right. So Ray, I haven't brought you into this discussion. So tell us, maybe, I know you've probably had some experiences where waiting on introducing a term or introducing it too early can cause problems. So why don't you talk about how you've dealt with those?
I like Frank's analogy on sleeping dogs. You know, a lot of it depends on the case. You know, if it's a defamation case, you know, you're going to be dealing with some issues, perhaps not dealing with money at some point. But, you know, you have parents who may say, in a med mal case, I don't want this to happen to my child. I want the protocols changed in the NICU. And so it can vary in terms of what they want. I had a woman who later became the poster child for tort reform in North Carolina. I'm going to write a book about this. And I do think it's incumbent upon the mediator to say, well, that's probably not going to happen. If we get it resolved today, there's probably going to be a confidentiality clause. And she and I, we were talking directly with each other at the time. You know, I'm supposed to be building trust, and hey, great job. But I said, well, let's see what happens. Let's run the numbers. And I understand exactly why you want to do this, but we may have a problem later. And we worked hard. At midnight, I brought in the standard terms and conditions from the defense firm. She tore them up in front of me. And I said, well, what do you want me to do with this? And so she ended up signing it. But so I think it depends. The thing that generally backs people up, and you do have to be very situation specific. I said, well, be careful, because you want this, but if you introduce this now, that may affect your money. They may want to say, oh, yeah, we'll do this, but we'll make a contribution to the foundation, but we're not going to pay you but so much in indemnity. So you may want to wait. And the lawyer, usually a good lawyer, will say, yeah, that's true. Let's wait. But you can wait too long. I'm like Frank. I don't bring it up because I think it's incumbent upon the lawyer and the client to bring it back up. But I've not forgotten it. And I may say, I'm a little bit worried about, you remember we talked about this at 10 o'clock. I'm a little bit worried about this. But you also say, you know, to get this, you know, a jury cannot give you this. And so how do you value this as part of your settlement? And an apology in a defamation case can be worth a lot to a claimant. And, you know, maybe in an employment case, you also see that as well. But it's really how much you value it. But I do think it's incumbent upon the mediator to kind of raise his or her hand, warning ahead. You know, this may affect your money. It may not be something they're willing to do, but let's move ahead and see what happens.
And you know, kind of conversely, I've had a party introduce a term that even the lawyer didn't know about as you're getting ready to sign the deal. For example, a plaintiff in one of my mediations said she had over $100,000 in unreimbursed expenses that she was just assuming would be included as part of the agreement. I mean, that's a big number. And so her attorney was shocked. I was shocked. I couldn't even imagine going for, a couple of years without being reimbursed for $100,000. But this person had and introduced it at the last minute. And of course, the defendant hit the roof. So have you had things like that happen?
No, I usually take care of every problem in the first session. I never have surprises like that. No, and I see that a little bit different, but usually you'll take a deep breath, all of us, but it's going to come up in the context of the formal settlement agreement or may come up. So you maybe get lawyers together and say, I wish we'd talked about this, but it's not going to go away. $100,000, we're just going to have to deal with it. And, if it's something non-monetary, how do we work around it? And yes, we have those kind of surprise terms at the end, but I don't know. I just think you just have to swallow hard and deal with it. And at some point, I may say to a lawyer, I wish you all had brought this up earlier. I mean, and lawyers get it, but the lawyer may not have known about it, as you say. Yeah, so you just have to bite the bullet and do the best you can, and you may not have a settlement with that kind of swing. If it's I want a plaque up about my daughter who died, that's different. Those are very tough ontological kinds of issues, and everybody's committed to work hard, and hopefully it's something you can do at the end. But no, those can be tough.
And in that case, actually, what I did was I asked the attorney to talk to his client privately after I probably looked like I was going to faint. And he did, and ultimately it worked out, but it was a very difficult situation. And then, I've had another one recently where there was one term that we would all consider just common, and they're in every agreement, they're acceptable. And the document had been exchanged, and then at the last minute, there's an objection to one of the basic terms. And we had gone long, and I don't know if it was fatigue or what, but it caused lots of angst. And so basically what we did was we just stepped away and let everybody think about it overnight. And then ultimately, the parties were able to come together. So sometimes if you've worked really hard, you've gotten to a point where the settlement's almost done and something trips you up. While we really want to go ahead and get that agreement, sometimes I think it's better to let people step back and think about what's going to happen if they don't reach the agreement and sleep on that. Frank?
I don't know that this helps solve the problem at all, but I think it is a frame around it. And I always like to understand the frame around the picture that I'm working with. I believe I've had times where people were doing it strategically, that they think that they are great negotiators and they've read at least 2 books on the subject. And so they believe that getting the other side cornered into a deal that they like, and then throwing one more term on the table is a brilliant negotiating ploy. I'm positive I've had that at least once in my life where somebody was doing it what they thought was strategically, and they just were absolutely convinced that this was not going to blow up an otherwise good deal because they had the other side cornered. So just be aware. I'm not sure that being aware of it solves anything, but just be aware of it. I think there are times when people are doing it strategically, trying to, like I say, get the other side of the corner where they've got a deal so good they're not going to walk away just because you throw another term on top of it. And I'm all but positive I've had that happen at least a couple of times. And how you deal with it, you just keep on working. So like, Ann was just saying, just patience and keep on working, and, just go back into the process and keep trying to get the people closer and closer. If they won't take it, if you know if the other side won't take this new term, well, is there some way of modifying that term that is close to what the other side wants, that is something that's more acceptable to you, and just keep negotiating. But anyway, just throwing that observation out there.
Well, and now I would like to go back to something that Trish raised in her opening comments, just because I see it, and I've actually had somebody have a conversation with me about this recently, that you know, the summary judgment looming, and it may not be the same in other types of cases, but scheduling the summary judgment motion is out of our hands. We don't have anything to do with that. That may be the court system, it may be the parties. And I know the plaintiff's attorneys feel like defendants use that to hang over their heads in employment cases, because summary judgment is granted in a huge percentage of cases. But the plaintiffs, you know, maybe would like to have the summary judgment motion ruled on before they enter into mediation, because they don't want to spend time paying the mediator and all the effort if the case is going to be dismissed, or the defense counsel just constantly mentions it and insists they're going to get summary judgment and puts a very low value on the case. If you folks would just talk about that a little bit too, how you handle that when the discussion comes up. Do you ever talk about that in scheduling the mediation? And if there are any other kinds of motions in family law cases, maybe mention that, Tara, that people threaten or use as a way not to engage in serious settlement discussions. Trish, you want to, or go ahead, Tara.
For family law, I mean, what I've seen people have to deal with is that nobody wants to comply with discovery. And so there's always the argument of, well, we don't have the documents, we can't settle the case, right? And so they try to push it back and push it back. And the reality is you can settle anything. You don't have to have the documents, but it's helpful if you know what you're working with, right? So that's always a fun one to have to try to navigate around and figure out the timing of it.
Do you have any tips for how you would navigate around it?
So it's one of those things where the deadline is the deadline. So from my seat in my ivory tower over here, I'm going to tell mediators that they have to schedule the mediation before the deadline, whether discovery is complete or not. And if the parties are filing motions to compel, and if they don't get those motions heard, we still have to have the mediation, right? And then in that case, you hold the mediation for an hour, and then you impasse the case, and then you tell the parties you want to work with them down the line once they do have their discovery issues sorted out. And that's if you can't get the extension. And some courts are better about the extension process than others. So you really never know what you're going to get depending on your location.
So, and Ray, I saw you might have a comment.
Yeah, I would just, this one of the wonderful things about being a mediator is I think one size doesn't fit all. And this is a good example of where you have to be kind of situation specific. I like having mediations in the shadow of a dispositive motion. But I also think it's one of the few times where a mediator can sow chaos and confusion. If I go into the defense room, if you're in federal court, obviously the chances of summary judgment are greater, perhaps business court, but state court, come on. Yeah, that's not going to happen. And look at this fact and look at that fact. And, you're the defense lawyer. I don't know. I'm not sure I would grant it. And then the other room, I'm going, I don't know. They could get summary judgment. It's, they've got a pretty good case. And I think you absolutely have discretion to sow a little doubt in both rooms. But if you'll move here and you'll move there, but the challenge you've identified, and I think in employment cases and to some extent in medical malpractice cases, the case changes radically if summary judgment motion is denied. And that's a reality. And so you're really there to see what the defendant is prepared to pay in the face of the dispositive motion. And your job as a neutral maybe is to, I'm not so sure about that. I'm not so sure you're going to get that from Judge so-and-so or so, and you may, but you may not. And look how much you're going to spend if you don't do that. And the number may get higher. But you're right. You're not involved with the scheduling of it, but I don't mind I don't mind doing that in the context of dispositive motion because it makes people truly focus on the case and the issues and the finality of what could happen.
Yeah, and I mean, so I kind of do it through questions like, well, but what happens if you don't get summary judgment? You know, let's put that aside. What do you think your risks are? How do you value the case if it goes to the jury? You know, what about this sympathetic fact or this sympathetic fact? Have you done jury verdict research in the area? Are there any jury verdicts that have resulted in this? And so I know it's a problem, and I know that particularly plaintiffs' counsel that I deal with are very frustrated by it, and would really wish that the courts would just go ahead and expedite the summary judgment rulings, especially in federal court, but we don't have control over that. And if we've got a deadline, we've got to hold mediation within that deadline. Jackie, is there any issue in workers' comp cases that are similar to that you have to worry about?
Well, I think in workers' comp, I actually was going to comment on in Superior Court, but going to workers' comp, I mean, it's mainly just trying to value the case, and if you've got bad facts, the other side may be telling you how bad the facts are, but it will drive the value of the case and what you're willing to accept. And just segueing back to Superior Court, I get this a lot. We've filed the summary judgment motion and we're going to win. And, you really just need to try to pull back. It may be something where they're trying to say the attorney did something wrong, that, they sued the wrong party, or, things like that. If it's straight up malpractice, then obviously we have different ethical, requirements. But, one side will realize that they don't have a very strong case. Give them an out, so to speak. Let's focus on the facts of the case. Slip and fall. They're some of the hardest cases for plaintiffs in North Carolina. Was it open and obvious, that kind of thing, so that you can, exactly to Deborah's point, maintain everyone's dignity. I don't know if you can see that comment that Deborah has. That's exactly what I'm getting at. You've got to, let's just talk about how difficult these cases are in North Carolina, and the side that has the weakest case, it's going to be reflected in the settlement and the value. And so you don't have to say, I think they've got to, you got to worry about this maybe. You don't have to get into that. You just talk about the case, what if this happens? And so I think you really do, to Deborah's point, have to pull the focus back to, let's just talk about the facts. Because nobody wants to think they're going to lose at summary judgment. But they should be considering, those facts, just like in a workers' comp case. Have we got a case that stinks? Well, if the case stinks, then let's get it settled at mediation. And I think it's the same thing when you've got summary judgment pending. And also to your question about scheduling, do you schedule it after the motion's heard? I mean, a lot of times, to Tara's point, you run into scheduling deadlines and you have problems with that. But if it is if let's say a defendant is absolutely convinced, they're not going to schedule that mediation until that motion's heard. I mean, if they've just got a slam dunk case, which, to Ray's point, that's why you go on and try to get it scheduled. So you've really got ammunition to go in and, let's get this case settled.
Well, and so what do you do, and this just to the panel, when you have someone who is representing a party and they are inexperienced and they believe like absolutely they're going to get past summary judgment, and you've been practicing this area a long time and you are pretty convinced, and I know we're not supposed to have opinions, Tara, but pretty convinced that they're not going to get past summary judgment just based on your experience as an attorney and in these cases. How do you address that with the particularly the plaintiff's counsel? I mean, I've seen that where somebody's like, well, they're questions of fact. Obviously, we're going to get past summary judgment. And, in employment cases, it just doesn't work that easily. Any thoughts, any ways that you would handle that? Because you don't want to say, are you sure about that? Or take the attorney into the private room. Do you ask them, can you show me a case? I mean, to take to the other side, what do you do?
It doesn't always work, but I use the defendant's attorney's brain against the plaintiff's attorney. In other words, I'm not stating my opinions, I'm not doing my evaluation, but I'm telling the plaintiff's attorney what I'm hearing in the defendant's room. And whether I do it with them privately, or preferably I start off with their client there, so their client's hearing all these arguable horrors of the case. But occasionally, if I think that the plaintiff's attorney just really doesn't know the law, the most striking example I've ever had that I remember, let me put it that way, is a plaintiff, is the Fourth Circuit Court of Appeals. The plaintiff's attorney had lost summary judgment in district court on an employment case. And for those of y'all that are not employment lawyers, the federal statute, the federal cap is $300,000 on damages in the United States. I mean, I know there's little fuzzy lines related to it, but it's basically $300,000. And the plaintiff's attorney came in and demanded to settle this case where she's on the wrong side of summary judgment in the district court, $500,000. So clearly she did not understand her case, didn't understand the law, etc. So in that case, I took her aside privately and discussed with her not my evaluation of the law, but what the defendant is telling me the law is, and even went so far as to look it up on her computer as to what federal statute whatever said. And we still didn't settle the case because she just was kind of way in over her head, unfortunately, and so she was too afraid to let go of something big that she never got in the ballpark. I mean, the case maybe would have settled for $20,000 to $50,000, but I couldn't get her below $200,000. So.
Other
but
thoughts about
but
that?
the point of the story is, but what I do is I try to use, and it doesn't always work. Sometimes the uneducated person just digs in, but I try to use what the other side's telling me, against the person who's being unreasonable.
Yeah,
I've got a really
sometimes-
good family law story.
Oh, please, Tara.
Okay, so this is like way back in the day, and I was representing my client who, of course, told me the truth about everything, and I had all this great information.
Absolutely.
And we went into mediation, and we were about 4 or 5 hours in, and we were adamant that we were not going to pay, any type of alimony, that we were not going to do, this, we were not going to do that. And I was digging my heels in. My client was an upstanding, person in that marriage, blah, blah, blah. And after a while, we weren't going anywhere. And the mediator pulled me out of the room and pulled the attorney from the other side out of the room and said, okay, look, I can't share the information, but I need you to have a conversation about how alimony works and how this is going to move forward. And the other attorney finally looked at me and said, your client is going to pay alimony, and if you force me to go to court, it will be incredibly embarrassing. And I said, I don't know what you're talking about. I don't understand where you're coming from, because the law is clearly this and this and this. And then the other attorney finally pulls out of their bag 2 inches of documents that was like watching an X-rated movie with my client starring in it. And my jaw just dropped. I was like, oh my gosh, I was just absolutely floored, because everything that I was looking at was incredibly incriminating, and I had no idea that it even existed. And so I said, excuse me, just for 1 minute, may I borrow this information and share it with my client? And they said, yes. So I took the information, I walked into the room with my client, I set it down, and I said, we are going to settle this case today. And we did, right? But I had, as the attorney, I was like, oh, my client's, on the up and up and everything's going great. And the mediator was crafty
Yeah.
enough to literally pull it out of the other side because the other side didn't want to share the information. The opposing counsel thought that they had a better chance going to court and presenting all of that information in testimony and as evidence. And, I think that the mediator had to literally convince them to share it with us and, say, look, if you share this information, this case will settle. And sure enough, man, it settled real fast.
And that's an excellent point, Tara, because I have also found sometimes if you just put the attorneys together, that things that they tell you absolutely you can't tell the other side, you put them together and you'll sit there in awe as a mediator as one of the attorneys is telling things that you were sworn to secrecy about. And that can be a helpful way to get the parties unstuck. And somebody notes that you have to remember truth is defined differently by parties. They don't necessarily have the same perspective as to what that really means in a case. Ray, you look like you're going to add something.
Well, just more mischief. I do think the best process is if you're getting a young lawyer, inexperienced lawyer, or just any type of lawyer, is to talk to him or her outside the presence of your client. To me, a cardinal rule is you can't divide a lawyer with their clients because obviously they've just met you to have some back and forth discussion about what do you know about Rule 56. You talk outside. What am I missing? Or you put lawyers together and usually they're not so slow to show X-rated movies. Usually they'll come out pretty quickly. But here's the problem. But yeah, and also what I mentioned earlier, coming in the face of emotion and sowing a little bit of chaos, it would be. I want to make sure I'm not over speaking. It's more the classic mediator head scratching. I'm just not so sure about that, or I'm not so sure about that. It's not. What do you know? It's more. I'm not so sure. Judge, I appeared in front of Judge so and so, or this. What about this? What about that? We don't want neutrals coming in and announcing what's going to happen. And the humility I do have some. The humility I have as a practitioner. What do I know? I thought I was, from trying cases and from losing motions of summary judgment, you really don't know what's going to happen. And that kind of keeps me humble. And I say, that may happen, but I just, there's always a little voice in me that says, maybe Judge So will grant that. That keeps me a little bit humble in my own opinions, but you have to bring lawyers out. You can't fuss at them in the presence of the clients, even if you'd like to.
And I've went to one seminar where the premise was, be like Columbo. Probably a lot of you don't even remember Columbo, but it's just like, well, so help me out here. Help me understand why you're so convinced. Help me in this. Help me understand. And I think that's a good, perhaps, way to approach it too. You won't necessarily get what you need to resolve the case, but at least it's not as threatening and raising the issue. One other topic I want to talk about just while we've got a few more minutes left, and again, I know we've all had this, when a party brings someone to the mediation who throws a wrench in the discussions, who doesn't want to settle it, who takes over the mediation, who tells the party what to do when it's not the participant's role. If you can talk a little bit about those experiences and what you've done. I've had sisters, brothers, mothers, fathers, children, insurance examiners from the outside who have been hired to only come into one case. I mean, I've had all kinds of things happen. And, in hindsight, I always know what to do. But while you're in the middle of it, it can sometimes be challenging. Any thoughts about that and any solutions or suggestions that you have?
Are
that
your,
is quite.
and are your, is your hypothetical, is the party represented by an attorney?
Yes, yes, even when they're represented by an attorney. And I've had the attorney say, I know the husband's coming with me and he's the problem. So, help me. What do you do? And I'll just give an example of mine. So I had a husband come with me to mediation. A woman had sued for discrimination, and I could tell, Trish, you talk about being intuitive. I could tell she really wanted to settle the case, but the husband was very domineering and didn't want her to settle and wanted to get a big amount from the company. She had been terminated. And so finally, I just looked at him and said, well, I'd like to talk to your wife alone. And he said, no. And I said, well, but I would, she's the party to the case, and she would not wouldn't let him leave. And that was a very difficult experience. It ultimately settled, but it was almost as if he was abusive in that situation. And should I have, adjourned the mediation? Should I have done something? Now I defaulted in some cases to, at the beginning, saying when I kind of have a heads up, I want to make it clear that I may want to talk to the party without the person who's accompanying them at some point. So don't be surprised when that happens. And I'm sure you'll be willing to step out, won't you, when that happens? But you have to do that at the beginning, and you have to have some sense that that would be appropriate. Has nobody else had that happen?
I've had it happen. I just feel bad because I feel like I'm talking so much.
No.
So in family law, it was very common to have the paramour come with the client, and they were often very controlling. And so we always had to figure out how to read the client to determine whether they were able to make decisions without their boyfriend or girlfriend standing right beside them. There were many times where the client needed the support, and it turned out to be a really good thing. And then there are the other times where, the third party is completely interfering with the whole process, and, the client's just not making good decisions. So the impossible answer is you kind of have to read the client to see if they're able to give consent, if they understand the process, if they truly are willing to agree to the terms that are being discussed, because it's that person who's going to live with the result of that mediation. And then the mediator either, needs to remove the interfering party or move forward and try to get the parties into a settlement. But one thing that I would encourage all mediators is, settlements are fabulous, but if it's not going to work for the parties, right, then maybe that's not the best option. Maybe they need to go to court.
Well, and so Tara, would you have, in the situation I described, been confrontational with the husband and asked him to leave, or would you just have let it play out?
I mean, it's hard to say in, like a 2-minute conversation, but if your client didn't want him to leave, I probably would have let it play out just the way that you did. Creating a confrontation, and even if the wife and the husband were in an abusive relationship, the wife's, there with her husband, and I think trying to drive a wedge in between and explaining to the wife, your husband's being abusive, I need him to leave, even if you do it in soft terms, I don't think would go over well at all. So I probably would have done the exact same thing.
Okay. All right. Well,
it is a tough situation, and I guess my concern, I would certainly push. I can be pushy, sometimes more pushy than I should be, but I would certainly push. But at the end of the day, my concern is that we wind up with an agreement that simply gets shredded tomorrow, because the guy storms out because he's mad at me, goes home. She shows up with an agreement, and figuratively or literally, he tears it up, and now we're back at square one with no agreement, except for now we have an argument over whether that agreement was enforceable or not, and we just have now another layer of litigation on top of the old litigation. So my preference is to try to set it up for long-term agreement, not just agreement at the end of the day, but make sure this agreement will last. And if we got somebody who's really upset about the process, et cetera, then I may have simply negotiated a hand grenade.
All good points. Rick, I want to bring you into this again because of your experience with pro se parties. You know, I've had another situation with a pro se party where the pro se party brought her brother, and the brother took over the negotiations and discussions and was not the party, but the sister needed him to be there, wanted him to be there, didn't feel like she could make discussions, and he was again just overbearing. But it's pro se, no attorney involved. Have you had that happen?
Well, thankfully, no. I've not had to deal with that. I was trying to think how I would deal with that if it came up.
That's why I have Jackie and Tara on speed dial, because I call them and all of the folks here, because I have just, maybe it's just me. Maybe I attract all these crazy cases. But
well,
You
I
get
mean,
hard cases.
yeah, I mean, I can speculate if you want me to, but
sure, please.
This is court ordered, so the mediator's in charge of the mediation. I think it's always it's fair in terms of sort of being a negotiation coach to explore how things are going with people. And so then that if you're going to do that, you're going to have to be as tactful as you can be. And I hope we're all pretty tactful. I think it's an important trait in mediators to explore, how this is going. Let's go back to step one. This is a meeting to try to negotiate a settlement. You have your day in court. It's coming up if you can't get this settled today. So where are you headed and how do you want to get there? And maybe we can talk, it doesn't seem like we're getting there right now. Can we talk about a different way of approaching this and maybe just go over it and over it with them? And I always remember it's their conflict. It's not mine. And I want to help them settle it. But if they're not capable for whatever reason, they don't have enough information in any way, or they just are set on one thing and they're not going to budge. That's not my job. I do everything I can to try to work with them to get to a settlement. But at the end of the day, it's I can look at them and say, well, sounds like we're just, there's no common ground here. I'm available if you want to come back before you get into court. Can I check back with you in a couple of weeks? Something like that. But that's just, spitballing it right now. I'm not, I hope that never happens to me. I hope I never have to deal with that in real life.
I think there are kind of two categories of misbehavior by non-parties. One is you have some notice about it. That is, the other side has called you. They want to come with their boyfriend and he packed heat at the deposition, or it could be any, or this is a difficult hedge fund person, and so you've got some notice. And I always encourage them, much to people's consternation, you need to let them into the process. If you don't have them there, they're going to throw bombs the entire mediation. Your mother-in-law is going to tell you, don't do this. It doesn't feel good. And then when we have the mediation, I try to be in the early rounds, like a question I will always ask the plaintiff, and maybe in your case, Ann, I think you handled this other issue absolutely the right way. I will ask them, what's your goal today? And they're never ready for that question. I one time had a lawyer jump up and put his hand over his client's mouth. I don't want a number, but what's your goal today? Because people struggle a little bit with, and eventually they get to, well, I'd like to get this resolved today. Today is the day. And then I will turn to the biker from Hickory and I'll say, okay, what's your goal today? I'll ask him, even though I really shouldn't ask him. I try to be deferential and, wow, I wish I could ride a hog like you. And, I try to build some bridges. And he feels honored, if you will, or valued in the process, although legally he obviously doesn't have a right to be there. And if they misbehave, I'll generally be, they didn't have to let you be part of this process, but they agreed to do it. They could have said no to your attendance. And so we want you to be here. But you told me your goal, it took you a while, is to resolve this. But if they have different goals, if the husband and wife have different goals, wow, I'm worried I'm going to end up with your hypothetical, or not your hypothetical, the real situation. There's going to come a time, and I would point it out. You all had different goals in the very first session. Our goal today is to resolve the case, but that's all you can do. And, they have to vent too. But I think if you exclude them from the process, you've got a guaranteed impasse coming. And I agree with Rick. I learned a long time ago, I'm going to sleep just fine tonight, because some people just need to try their case, and some people aren't ready to resolve it. And we all know that. They're just not, the conditions are not ripe for resolution. And that's okay. You may see them again.
And Ray, I think that's a great point, even in any mediation, to ask the parties, what's your goal here today? And then when they say it's resolution, when you come back and you see they're doing something that is throwing a hand grenade into the discussion, I heard you say at the beginning you wanted to resolve this. How do you think that's advancing the process and putting that back on them?
It's very devious, but it works sometimes.
That's great. So, all right. So it is 9:30. Kyle is telling me. I appreciate everyone being here, being present, all those in attendance. We will have this recording available. We are working on doing another roundtable that has to do with AI. Jim Cooley is pointing out that we're already behind in learning about AI, so we're going to have a roundtable about that soon. So thank you very much.
Thank you.